Judicial review is a court process in exercising the supervisory jurisdiction in proceeding, judgment, act, and omission of the public authority. It can be applied under Order 53 of the Rule of Court 2012. The court will grant the order for judicial review based on the ground of illegality, unreasonableness, or irrationality, and procedural impropriety. This means that judicial review will be carried out if the decision is ultra-virus, which the decision maker have acted outside of its conferred power to prohibit this authority exercise power beyond their two legal limits.
Generally, it is not all decision-making authorities are amenable to judicial review. In determining the amenability of authorities to judicial review, the reference should be made to the source of power of the authorities. There are two types of source of power. Firstly, the written law. The power delegated from written law means that the decision-making power of the authorities are delegated from legislative provisions or constitution. The authorities whose decision-making power is delegated from legislative provisions or constitution is subject to judicial review. For instance, under the Industrial Relations Act 1967, the Industrial Court have the power to hear and determine industrial-related dispute, bring before it, and its decisions are subject to judicial review. That is to say, the authorities with statutory decision-making power are most likely be amenable to judicial review. For the second source of power, it is not traceable to written law. The amenability of those authorities to judicial review depends on the nature and function of the exercise of their power. The authorities will be amenable to judicial review provided that the exercise of the power has extended for the purpose of governmental control. Otherwise, if it is for the non-governmental purpose, it will not be amenable to judicial review. Hence, it can be concluded that the public element in the exercise of such power by the authorities is crucial for the determination of amenability of authorities to judicial review.
The issue of whether judicial review is available to a party which is a corporation or a private organization that performing public responsibility governed by a statute need to be concerned. This issue was illustrated in the case of Tenaga Nasional Berhad versus Tenaga Prospecting Sendirian Berhad, where the appellant is a public company limited by share licensed under Electricity Supply Act 1990, where it possesses certain statutory power. The Court of Appeal held that if the appellant behavior comes within the private law domain, judicial review will not be available. But if the activity falls within the public law domain, judicial review will be available.
Corporate authority ruling subject to judicial review may be rare, but OSK case is the landmark exceptional case. The court held that KLSE will have a future as is formed under the Company Act, but is governed by the governance authorities. As a public aspect on contractual obligation between the partners is amenable to judicial review. However, judgment in OSK case is narrow. This caused gap between the genius standing of corporate authority in terms of judicial review and how Malaysian court address it. Therefore, the judgment in the Tan Kok Han case created doubt in the OSK case in identifying the determination of authority that will be reviewable by the court. In Tan Kok Han case, appearance of judicial review of Tanah Harta ruling in the High Court based on the judgment of the Wong Kuk Sen case, which consider the source of power exercised by authority rather than the nature of the authority power. Thus, the court held that Tanah Harta is a private corporation under the province of private law rather than the public law. It should be emphasized that Tanah Harta is subject to judicial review by saying that it is incorporated under the Company Act and operate as a company to manage the asset.
To determine the issues of government-linked company that is subject to judicial review or not, His Lordship went further to determine the issue by divided corporations into 3 types of corporations. Whether this corporation was subject to judicial review or not will based on the nature and features of the corporations. For example, for the first company is related to the company that is formed under the Company Act. They perform no public functions, they perform no vested power from the statutory law. Even these companies are governed by the government for its important shares and board of directors. However, this company will not subject to judicial review. For example, for this first type of corporations will be Malaysia's airline system. This corporations, even though is governed by the government, but its features is in private law nature and not within the ambit of public law. So these corporations were not amenable to judicial review. And for the second type of corporations, according to his lordship, is referred to hybrid corporations. Hybrid corporations is mean that these corporations will have both feature public and also private. For these corporations is normally incorporated under the privatizations program and is referred to publicly owned service company, for example Telecom Malaysia and also Tenaga Nasional Berhad. For this type of company, their share is not only limited to government but also governed by many other peoples. So for this type of corporations, their suitability to judicial review will only based on the act or omissions complained of. If this company added in the public law domain, will be subject to judicial review. However, if added outside the public law, which is fall within the private feature, so this company will not be amenable to judicial review. For third type of corporations, according to his lordship, is referred to corporations that are solely owned by the government, public funded, and also have the power vested on it. So for this third type of corporations, they are government instrument in truth and substance. So for the facts of the case, his lordship opined that Tanah Harta should be fall within the ambit of third corporation, so amenable to judicial review because of the gist of person and authority defined in paragraph 1 schedule of the Court of Judicature Act is found similarly to the government instrument in truth and substance that vested in the third corporations category. So his lordship went further that Tanah Harta should be amenable to judicial review because of these features. It is worth noting that His Lordship Gopal Sriram, in addressing his judgment in regards to the issues of amendability for a body that is subject to judicial review, His Lordship have then further to make 2 subject matter for these issues to be decided. First, there should be a division in between amendability and also justiciability. And the second one is related to government decisions made in corporations and how these corporations should be amenable to judicial review. And for his judgment, he opined that issues of amendability should be distinguished from the issues of justiciability. It is because that even a public authority subjected to judicial review, however the matter subject to judicial review may not that suitable if the case is related to political issue. It is worth noting that when Tan Kuan Han case appeared to the highest court of the land, Federal Court, the learned Federal Court judge also found that Tanah Harta should not amenable to judicial review. It's not because of a feature, it's not because of the functions of the corporation stated before by His Lordship Gopal Sriram at the Court of Appeal, but because of Section 72 of the Pengurusan Tanah Harta Nasional Berhad Act is especially prohibited the courts from exercising its judicial power over its body judgment. So it is clear that Malaysia's court are very cautious at closing the line in between the public law domain and also private law domains in determining the issues of amendability of the body that is subject to judicial review.
To summarize it, generally, when the source of power of public authorities is from the written law and exercise functions in public nature, it will be subject to judicial review. However, when the amenability of authority to judicial review is purely private rights, or it is derived from a contract, or even is related to a political concerns, even though it is public authority, but the judicial review were inapplicable in these cases. It means when the corporate is fall under the regulation and incorporated under the public authority, this corporate will not be bound to amenable to the judicial review. However, when it is a hybrid corporation in which it possesses public and private features and perform duties based on the contractual obligations in private domain, acted by the power given by the statutory authority to be in charge in performing public duties, it will be entitled to judicial review, but the court will consider the acts or omission complaints of. However, in respect of this kind of case, the court apply it based on very narrow grounds in very limited circumstances. That's all for our presentation. Thank you.